Hello viewers, welcome to yet another episode of the Youth Roundtable. And today we bring to you a rather very contentious conversation, which is the issue of human rights. Uganda, as you may know, has had quite a unique history in terms of respect, promotion, and the evaluation of human rights in its sense. From ratifying multiple international conventions like the International Convention on Civil and Political Rights, the International Covenant Against Torture, the Maputo Protocol on the Rights of Women, among other international conventions. And domestically, we have an entire chapter, Chapter 4, set aside to, just talk about the Bill of Rights. So the question therefore remains that with all this legislation in place, vis-a-vis the context that we see on ground, how has the year 2024 been with regards to our human rights situation in the country? And we shall go, far and wide to explore this particular topic. And I'm joined by a panel of distinguished, eminent young people that is now my pleasure to introduce to you, and in, of course, no particular order. From my immediate left, which is obviously your right, is Agatha Achola. Agatha is a student of law at IU Kampala campus. Agatha, it's a pleasure to have you.
Pleasure meeting you too.
Yeah, is it the first time on the Youth Roundtable?
Yes.
How do you feel? You made an appearance.
I feel nervous.
Really? No, calm down. It's a very youthful show, and you should not be nervous. Yeah. Next to Achola is a gentleman who you have seen on this show not once and not twice. He served as the 6th Speaker of the National Youth Parliament. The name is Sam Okot-Ola. He's also a lawyer by training. Sam, it's a pleasure.
Thank you very much. It's good to be here.
You had chucked the Youth Roundtable.
I'm back with this.
You're back with the bang. Yeah. Yeah. Next to Sam is Melody Nakalanzi, who is also a student at Makerere University. Melody, how do you feel being on the show?
Well, I feel fine. It is interesting and amazing to be in such a conversation. Yeah, I was here before talking about youth protests, and it is always an amazing discussion and engagement here.
Yeah. Okay, well, let's just begin from right there. The issue of protests, and each time Ugandans have come out to try to exercise this right, the police has always evoked the limitation that, for as long as in the exercise of this right you infringe on the rights of others, then we have every duty to stop you. I don't know, how do you think the police has performed in terms of the right to freedom of, association, or freedom to strike or to riot?
Well, now I am not very sure about how some of these rights are actually stated, but as best as I know, there is a right of expression, right? Yeah. At a time when someone has a grievance, they have the right to come out and say that I do not agree with how things are actually happening. At a time when you have, for example, I am a Makerere student, at a time when you have systems that are not favorable for young people, then they actually have a right to come up and say, we cannot do with this. Well, now the problem then comes that when I say I cannot do with this, then I come up and protest. But there is a lot of brutality from the police. The system is very suffocating. At a time when you say, I am going to protest or do this, you're scared of going to police, you're scared of being tortured, you're scared of being beaten. Like, everything around that then becomes very problematic, that even when you thought I should actually stand out and fight for what belongs to me, fight for what belongs to other people, then it becomes problematic. At this young age, no one wants to have a criminal record, right? So some of those things are actually very problematic, that even when I have a right, I know I can protest against something that is not right, then it becomes very hard that I cannot do it. One, you're going to be beaten, you're going to be tortured, you're going to be taken to police or whatever cells they take you to, and they'll do all sorts of things that are not human. And when they say that you're actually maybe doing things against the law, like people we saw protesting, then they put them on they say they were being idle and disordering community, you notice that that is not how things work. At a time when they say we are coming out to protest against something like corruption, that is something that is very significant. You're depriving people of the right to get access to social services or whatever that they are entitled to. And then when other people then decide to say we can stand in for the people that cannot, then it becomes then a problem to everyone. That you that has come out and said, I am going to help these people get what they want, then it becomes a problem to you. That you're going to be in cells, you're going to be tortured, you're going to be beaten, and then people are going to start investigating about you, they're going to look for your family, and all that then. Yeah, I think that is how problematic it is, especially in Uganda.
Wow, interesting. Sam, let me get you, and maybe just still on the right to protest or the freedom of association therein, is that there is a constitutional court decision in Mwanga Chivumbi versus Attorney General that, you know, declared certain provisions of POMA and the Police Act null and void. That the idea is that people should have freedom to associate and to, you know, express themselves. How do you juxtapose that decision of court vis-a-vis what we see on the ground, as she has expressed it? All these limitations, they stop you and all that, yet there's a constitutional court decision to that effect.
Well, there are many angles to it. As a lawyer, as someone who values human rights, it is indeed our right to come out, to speak, mention issues. But we cannot discuss the law. If anything, I learned from law school is that law is simply a facility. We need to discuss the law as a facility to understand the phenomenon that that is ongoing as a country. And indeed, right now we find ourselves in a situation where we really need to refresh the minds of what in politics they call the zeitgeist, the mood of the country. On the one hand, we have people extremely fatigued by long time in opposition without results, and of course you can look at it, as we said, most people will discuss rights in this sense. And on the other hand, we have a government that has also taken really quite long, and maybe the people who came, because I know NRA as a progressive force on many issues, refugees and so many issues, but you find that over time, perhaps the young guns, the young tanks, don't have the same self-esteem and comfort. And so they have a stronger arm in terms of enforcing what they believe as asserting their power. And so that is where the phenomenon we find ourselves. It's a phenomenon that precedes transition. There's a lot of distrust, a lot of anger, and so really, if the effect on us normal Ugandans is morale. If it affects your morale, but again we have to keep going. We have to keep making our stance. Ugandan youth. I remember during the protests, many came out from both parties to make their voice heard, irrespective of the concerns of security, which I believe we can debate it another day, but they were genuine. There was, of course, some psychops being delivered by the government, but by some foreign agents. By the end of the day, it's a complex, demoralizing.
But you see, okay, Sam, just to interject right there, is that the issue of foreign agency has again come up in this debate. So I'm just wondering, our government, I think our health sector is financed largely by UNAIDS, right? We get a lot of money from IMF, World Bank. So where do we draw the line? If funding is coming in to government, it is okay. But if it is coming in to all government accountable, then it is illicit financing. So where do we draw the line between good Western funding and bad Western funding?
Yeah, it's simple. Like, well, as even within Western funding, not all the money comes from one place.
Yeah.
The money for example, geopolitical military work does not come from USAID. It comes from another
Yeah.
another place. And the money for health, education, etc. comes from US aid. And so it's not that Western aid is one.
Is one.
Yeah, so we need to, well, if there will, if the, for me, I believe strongly as a Pan-Africanist that the world owes that. We donate to the world $400 billion per year in illicit exports from Africa. So I don't mind money coming in for health, for education, but I think that we should retain agency over the direction of our country. I don't think we owe them anything for their aid. It's only that we are not alive to the fact that we donate more to the West than they donate to us. And so in the case of the march to Parliament, it was preceded by the sanctioning of the speaker.
Yeah.
And so the need to create local conditions to justify those sanctions, which break issues of stare decisis, fair hearing, you know, and just put the speaker of the country on spot without any his interference in itself, but they had to create the local, and there was clear evidence of this funding. That is the interest of the state. Okay, it was not related to the young people. The young people were genuinely angry about corruption. We were there. I remember calling you many times that should we go? Should we go? Should we go? Because we didn't have the so I know it's a funny dilemma we find ourselves in, but at the end of the day we are all lawyers. It goes back to what we call rule of law.
Yeah.
Rule of law is a facility that helps us to negotiate our space in this place called Uganda. There's a genuine concern of the population that needs to be answered. Issues of service delivery have to be improved. Issues of corruption have to be dealt with. Those are the interests of the people, and we have to push it, that agenda. How do we push it? It's the voice of the people. So it is not in the state's interest to perpetually frustrate the voices of the people, because if they cannot negotiate in peaceful ways, then they will negotiate in other ways.
Through violence.
Rule of law means the citizens have to understand that the security has a genuine interest in the affairs and the future of the country.
In the country, yeah.
And how they negotiate, how they dispense information has to be there. Because without that, we cannot sit here, walk around and do a lot of things, all the way from sovereign security downwards. Rule of law includes the elite, the political elite and their interests. You know, what is the historical question of the North, the East, and how they bind in, and of course the economic elite, the rich. So at the end of the day, we have to sit. We have to create room for this negotiation, and that is what is ongoing. You know, that is what is ongoing. People don't see, but we're already in transition. People are negotiating their space. Last time the CDF said no civilian will ever rule Uganda. That's not a final statement. It's a negotiation from security. Yeah. So what are we countering it with? So I think that is where we are. But it's not in the state's interest to frustrate. It's not in the long-term interest to frustrate the right to speak, express themselves. And as of course youth in the NRM, we continue to advise accordingly, so that the mandate of the party speaks to the times.
Yeah.
Thank you.
Wow, yeah, interesting. Quite some depth there. Achola, let me come to you. And I will, of course, give a chance to make your comment with regards to how this whole right to freedom of association has been handled, but also the issue of torture that she mentioned. There is a constitutional court petition that is challenging, I think, Section 11 of the Human Rights Enforcement Act, which states that if it is established during a criminal trial that an accused person has been tortured in any way, that trial should become a nullity. Now that's the position of the law as it stands today. The Attorney General is saying that no. That mere torturing someone should not render the trial process a nullity and acquit the accused person. Where is the right of the alleged victim in here? So As you give us your comments on freedom of association, also the issue of torture and how delicate it is, but also how has it been handled in our jurisprudence?
Thank you so much. It's a disappointment to the country, more so when it comes to torture of human beings. Yes, an accused has been arrested and detained. I don't really see the reason as to why someone has to be tortured to the marrow, to the bone marrow, like the person is tortured and the person is again expected to be produced before court. And you really see someone being brought to court carried on the back, really? Anyway, it would not exonerate someone from serving what he or she committed. But I would not call it fair enough for someone to serve twice a punishment.
Double jeopardy.
Exactly, double jeopardy. So I really see there is a lacuna that has to be faced, and at least.
So is the Attorney General right in saying that an allegation of torture should not amount to nullification of a trial process? Because they are saying that, okay, now the alleged victim in this matter, you're going to acquit an accused person because of allegations of torture. But then where does that leave the victim? An accused person has probably committed, I don't know, an offense, allegedly, murder, rape, whatever it is.
Yes.
So if you acquit them because the state has tortured this individual, where does that leave the victim then?
To my stand, I would say yes, I would say no. Why? If it is a yes, justice is a win-win thing. So if someone commits an offense and someone is brought to serve justice, just because the person has been tortured, leading to an acquittal, we would not be serving justice to the other party. So I feel that is why I say it is a yes, it is a no. And it will not even act deterrent. It will not be a deterrent measure to that person because everyone else would see, since the other person was tortured and he was taken and being released, then who am I? Can't I also do the same and I be tortured? So it will not act a deterrent measure to the other party, seeing the same thing happening. Then maybe if someone has been tortured to the maximum and maybe that person has so far stayed, let's say in that detention place for quite some good time, maybe I feel it would be lenient enough to acquit such a person. I feel it would be lenient enough to acquit such a person, but basing on the time that person has spent in that detention place, the place of torture where he or she was.
So at that point, the fate of the victims on which whatever offense has been perpetrated then hangs in the balance. Because if you're saying that this accused person should be acquitted because of allegations of torture by the state, then how about the victims?
That's why I said in my standpoint it would be a yes, because justice is a win-win thing. We should not only serve to, just because this person is detained and he has been tortured, to exonerate him from serving what he did. We should also serve justice to the aggrieved party on the other side.
Remember, it's the state versus Uganda versus Ola, the murderer. It's not. So we need to look at the intentions of those who set it in place. The state is the monopoly of violence. It has power. It has the tools, and it's monopolized. That's a function of state. That's why it's the state versus the person, and therefore, in that sense, it's the state versus you. And if it beats you, you're supposed to be released. That is because we don't. Again, this is negotiation. You have no voice. So the only way we can, the people can negotiate with the state is that deterrent must stay.
So how about the victims? If
The
you're saying that they
victim,
should be
well, the state should not torture.
Yes.
And a worst case scenario, if you have good lawyers, there are other tools of recourse. If you remember the case of O.J. Simpson, it's far, but when the guy was acquitted for murder, you know our system is imperfect. A lot of murderers go scotch free because it's a system of weighing against a standard of what? Beyond reasonable doubt, which is very high for murder in many cases, and worse with rape. And so many things already go wrong. So perhaps we should have lawyers who are also specialized in getting civil claims
Yeah.
for
Actually,
for victims.
I would be interested on the ULS position on that, because I know you work very closely
With the president.
yes,
But that's
the
the
president.
position.
Because
That's the position.
because the Attorney General is advancing for that provision to be removed.
I think I speak the mind of the ULS president when I say that
Mm.
that is the last negotiating point. The day you're in you're in a cell, you'll not ask whether, you'll not say it's a yes and a no. You just don't know, because torture is a slippery
It's very
slope.
Yeah.
You don't know the mind of the torturer. The
It
guy
can,
can
it can
be
actually lead to
yes, the guy can be a gone case mentally. He takes away your manhood, takes away your backbone, takes away. So it just has to stay.
Yeah.
Otherwise, citizens should know how powerless they are
But then
once they hand over the social contract.
Why would the Attorney General, and I think let me just
No,
begin,
I
why would
just
the Attorney General
I
want
just
to
have
have
one
that
thing to ask
provision
you before
removed?
you ask
Yeah.
me. On what grounds does the state have the authority to torture these people? Because I guess even at a time when you're in detention for something or some crime you did, you still have some rights that protect you as a Ugandan or as an individual.
And you're innocent.
Yes,
Innocent.
because usually you're alleged to have done something.
Yes, yes.
So where then does the state come in to start torturing people?
I also look at that right, the presumption, the right to presumption of innocence. I feel it is really being abused. Yes.
But you see,
Because actually torture is a non-derogable right. It is like those rights that the state cannot limit at all. Article 44, it's
Yes,
a
yes.
non-derogable right.
Right.
So of course it is very unlawful for a state.
Sure.
And to me this is where I really wonder where the Attorney General gets the audacity to even want to amend that provision of the law. That is them saying that the state actually has the mandate to torture and has the intention to torture. Because if you have no intention to torture, then why should you be worried about a provision that nullifies a criminal trial premised on allegations of torture? I think it's a very unfound petition, and I would really want to see how it ends.
yeah.
Yeah, but yeah, I have to get back to Agatha here. Agatha, I'll give you some more
Agatha
time.
just said the presumption of innocence
Uh-uh.
is being
Yes.
abused.
Yes, it is being abused because someone is just being alleged. Why would someone be tortured as if?
Oh, okay, I
Yes.
understand, I
As
understand.
if someone has been like someone is presumed, like they're just alleging you for committing that offense. But the way someone is tortured, it really brings concern as though that person has been proved guilty to the point that he should suffer the kind of torture he's going through.
Yeah.
That is why I'm saying the presumption of innocence, that right of presumption to innocence is being abused in one way or the other.
Yeah, and I think that is to me one of the cornerstones of our criminal justice system, the presumption of innocence. But now that you've gotten us there, let's speak about the court martial, because one thing that is contentious is the right to a fair trial. Today we have civilians being tried in the court martial, and the president has come out clearly to say it's okay. Okay, it's okay for civilians to be tried in the court martial. They have proven. I mean, the court martial has proven to stabilize the country and all these things. But then you have a court martial where the chairman has no legal background whatsoever. So let me begin with you, Achwala. The trial of civilians in the court martial.
I look at the aspect of jurisdiction. I feel civilians should not be tried in the court martial because, as you hear court martial, it is only entitled to the army facing their trial. But where a civilian is got and being taken to a court martial, I really feel there is a lacuna that is in between the court martial and these other normal courts of ours.
But you lawyers are appearing before this court. You lawyers who are saying these courts have no jurisdiction, you are parading yourselves there to make a case. So aren't you in fact giving legitimacy? Because the same court that you're saying has no jurisdiction, then why appear before it? Aren't you in fact giving it legitimacy by appearing there? So the point I'm trying to show is the contradiction. that you don't believe that the court has jurisdiction, but at the same time you appear before it as lawyers to make a case before the same court. So, where does that leave us?
That's why I'm saying there is a big lacuna that needs to be addressed, because I don't really find it ethical enough for a civilian to be tried in a court martial, and yet its jurisdiction is not within the court martial. So I really feel there is a big lacuna that needs to be addressed in terms of that.
Sam, let me hear your opinion on the trial of civilians in court martial.
Well, let me answer like a professional. So here's the thing. The president's statement was that the court system is dead, in his opinion. It's not false. And also he stated, he brought what we call sociological school of thought in law, jurisprudential, that I'm here in Karamoja and these same court martials handled a problem, a civilian problem, where we had 41,000 guns in Karamoja, and how there was no way court systems with all its dysfunctions were going to handle that. That is noted. But I think...
So is the solution not to make these civil courts more efficient?
Exactly. Two wrongs don't make a right. So well, I don't want to comment on Kizabechi's case. The former soldier, the issue involves guns, etc. But and also sub judice. But this floodgate of trying civilians under the court martial, including supporters of dissident parties, I think is a wrong floodgate. It's something that will cause us problems in the long run. The court system, unfortunately, we are stuck in a place where the judicial system is dead. We have a Chief Justice who doesn't work. He hasn't worked for 3 years, and before that he hadn't worked for 2 years. Sorry, he didn't work for 3 years, apparently because of a short circuit in his office. And then he has sat on political cases, including the one in question. That was
actually the Supreme Court has not made
a decision for 3 years. Has not ruled on that appeal that was passed by the late Kakurus, and the cases there, among many cases, we have a Supreme Court that is operating on 10% performance. 10% performance. So such a situation.
So are you making a case for the justification of the efficiency of the court martial?
Well,
because when you juxtapose the inefficiencies of the civil processes, does that then give the justification that, okay, because this side is not functioning well, then we can use the...
No, I'm saying there are situations where a court martial is needed. I think in the situations, court martial in a sense of transformative justice, like in Karamoja, in Acholi, in Gachacha, Rwanda, though it works, but it should be short term. It should be transparent and should be open to the public.
Should it try civilians?
Yes. If the civilians have 41,000 guns.
What do you think?
No, listen. I need to, because I can be misquoted. I'm saying situations where you find yourself with a Karamoja with 41,000 guns, okay, that you need to handle swiftly. I think the court martial should be emboldened to hand. It should be open. It should be short term, and it should be for the greater purpose of justice, as it has done in Karamoja. In normal circumstances, no civilian should be tried in the court martial, as it is right now. And I think the point I'm making is that the justice system should be strengthened to be able to handle, because the High Court has unlimited admission to all cases, civil and criminal. And so one of the biggest injustices we are going to inherit as a generation is a dysfunctional judiciary. Because once the population gives up on the judiciary, the next thing is conflict. And so a lot of work must be done to clear up the backlog. Of course, it starts with the Chief Justice retiring, and we move on from we move on
Interesting.
from
Some
this situation.
has very radical proposals. But I have to bring you in, and I'll just read for you the UPDF Act, and that is section 119, which provides for the persons that shall be tried by the military
But
court
is it
martial.
radical for someone working on 10% to resign in any other profession, in any office?
No. So, it's in fact it has to be voluntary because you're here. But section 119 of the UPDF Act says that every person found in unlawful possession of arms, ammunition, or equipment ordinarily belonging to the monopoly of the defense forces can be tried in a military court martial. So it means that the trial of these civilians who have been found allegedly with these ammunition and equipment is a lawful thing. It is in our laws. So for us who are here arguing and saying that civilians shouldn't be tried in the court martial are actually arguing out of law. The law provides for them to be tried. So are we looking at amending the law, or?
Now, here is the first problem that comes with things to do with trying civilians in the court martial. The first thing is that the people that are representing in the court martial are people that do not have any background of the law. We have only generals that have not even stepped just a single day at a school of law or something anywhere. That is the first problem that we have. And then number two is that these people that are actually getting tried in the court martial are people that, I don't know, how do I state it, are people that maybe I think have like personal grievances with maybe whoever has put them there or something. But basically I'll just engage more on Chiza Message's issue.
Yeah.
Because this is a gentleman that has been imprisoned about 50 times. They say he's the man that has been imprisoned very many times in the whole world. So this is a man that has decided to like sit and focus on his life, focus on his family and things like that. So at a time when we have High Court having the responsibility to actually have all individuals being tried, then it becomes problematic that you're putting someone, well, you allege that they have done something against the law or something, and maybe it is justified.
No, the state is saying that these individuals were found with pistols.
Well,
So they were found in possession of equipment that should be in the possession of defense forces only. So according to the law as it stands, they actually can't be tried in a military court martial.
I told you, my first problem with them being tried in the court martial is that these people that are going to try them do not have what it takes to actually have these people tried.
Why?
Notice that UPDF or whatever police or people that should be tried there, those people have their kinds of laws and kinds of standards that they work with, right? So at a time when you have a civilian then getting tried that does not affiliate with those kinds of laws, then becomes problematic. That the people that are going to try this particular individual do not like sort of understand
Okay,
even what actually.
let me put to you a question. Let us put General David Muhozi with an LLB, a master's in law, as the chairman of the court martial. Does that take away your fears of these individuals lacking the legal knowledge?
50% it does.
So does it? Okay, once that fear is addressed, so it means the court can then go ahead and try.
Yes.
I
Civilians.
have a jurisprudential conflict with that.
Yeah.
It is elitist, and it's a plant of the British coloniality we live in to think that only lawyers can provide justice. In fact, lawyers in Uganda and people with LLB education like us here are the biggest midwives of injustice in the country.
Sure.
Yes. That is why the phenomenon of transitional justice, alternative justice systems come in. And it's not abnormal for civilians to be put on trial based on the conscience of ordinary civilians. It's the justice system of the US that every eligible voter, the jury, is made up of normal citizens who can decide on matters. So I don't think the issue is the education of the people there. The issue is the motives and whether those motives serve for the greater good. It is errant to think that lawyers, who by the way are the biggest, they have caused legal constipation of the judiciary, of cases. They are grabbing land.
So Sam, if
to
I'm
think that
understand
lawyers
right,
are the only people. Who,
no,
the only thing is,
I have to get you
there
right.
are two things. There's the motive, that is to bring justice, justice, and two, the procedure. Is there a fair hearing? Is there are they entitled to their rights as a prisoner? Those are the more important things. Let's not look at education.
So Sam, you're telling us that it is okay for someone who has no legal training to actually be able to sit and decide on a legal matter.
Well, it's
A matter which involves adducing evidence which is either admissible or inadmissible. How was it adduced? How was it gotten? How was the arrest performed? That someone who has no legal training at all should take that decision.
Yes.
I don't know.
I agree.
I'm conflicted.
I agree.
I don't know what you guys think.
The only issue is, are there the procedures to ensure that, one, in procedure, all the legal standards, as we ratified, fair hearing, upheld, their right as a prisoner are protected. It is very okay.
So how does this person who has no appreciation of the law know what you're telling us? That there is a right to a fair trial.
It's a,
there is a right to
It's the same thing as, just look at the US jury. These people don't know the law, but there's an institution of court that ensures the procedures are done right.
Yes.
Okay. There's the the legal gymnastics of forth and back, as you saw Aaron Kiza, etc. And then they decide based on their judgment.
Yes.
It is the same. It's the same.
We also have assessors
we have elders in the
We
village.
also have assessors here.
We have assessor. We have LC courts. People should know that the fastest justice.
But isn't the decision of the jury subject to confirmation by the judge?
No, it's a vote. Majority.
It's final.
Yes.
Okay.
And it's a whole school of
I didn't know because I know the judge has a duty to advise and to influence the
he does
assessors.
what you're doing here. He's a moderator of the affairs. But at the end of the day, if the two of us say this is guilty,
okay, Sam. Okay, Achola. I want to hear from you. Sam seems to persuade us that you don't need to be a lawyer or to have had legal training for you to make a decision, that you can use actually your common sense and your sixth sense.
I don't really find it right. Just like he spoke about the juries, the assessors. Yes, they are given that mandate to go on, maybe investigate on the ground or about that particular matter. But their decision is not binding. At the end of it all, it still comes back to the judge to determine. So I really don't find it ethical that someone who is not a lawyer is placed to present the other side. I don't really find it significant. Because now, how will that person understand the right to fair trial? How will that person address the right to habeas corpus? Like when it comes to the citizens.
Those are matters of institution, not the judgment of the person. Those are matters of institution. The court should know this person must be delivered in court. The court must know.
Sam, you're asking us to rely on someone's intuition, someone's ability to reason, someone's natural God-given intelligence, and forego the professional training that we go through for 5 years, and later on, because I think to be a judge you must have had 10 years in whatever practice. That all these procedures are put in place because we believe that by the time you get to that level, then you must have consumed so much legal knowledge.
We are detouring from the subject of human rights. We have gone into jurisprudence. But I genuinely believe. Believe that most cases solved fastest with LC1 involvement, with
alternative dispute
with
resolution.
elders. What justice is there for people who are knocked by accidents, apart from elders? In Acholi, who solved the Kanyamunyu case? So
no, but
was it the Kamegas who are DPPs, or it was Gorachana?
Case was tried in court and he was convicted.
This is far from the topic. But Sam, jurisprudentially,
let me just
we need
pick
to
our thoughts on this.
I guess,
get back to you.
there are some things that are that you can actually handle at whatever level you think they should be handled. But there are some instances where you actually need that kind of profession. So when Sam speaks that we do not need someone that has gone through legal practice to come and handle these things, it makes it look like then the entire law thing is irrelevant. Then why do we need the law? Why do we need?
That's not what I'm
why do we need?
That's okay.
Why do we then need to have Sam himself going to law school for 5 years? Wouldn't we just have village elders handling all these things at the end of the day, right? Because, well, they can do it. So then why then do we need your profession or your professional knowledge to come and handle these things? So at a time when you have civilians getting tried in court, in the court martial, it is very problematic, especially in Uganda. I do not know how the other legal systems work in other countries, but for Uganda, it is very problematic that we still have other issues as the country, and that even at the time when someone comes to defend someone in court, they are not given that chance and things like that. So it means what Sam is arguing for then becomes like it becomes something that we do not consider then, that at a time when you study law for 5 years and there is someone who can actually do what you studied for, then your role or what your significance is then we do not see it. Yeah.
Okay, I don't know, it's a bit of a tricky situation, because then I would want to ask myself that we have all these tribunals, for example, like we have the Uganda Tax Tribunal. I don't think the person who presides over that tribunal is a lawyer, but they make decisions. Even at university level, you are at MOOC. There is an internal disciplinary mechanism that suspends lecturers and students. I don't think people who do those things are lawyers. But I think for me, the point is the aspect of judicial review and also maybe the appellant process.
Appellant, yeah.
Yes.
What we should do to speed justice in Uganda, we should tribunalize as much as possible systems that enhance justice based on standards. If elders can deliver justice in our society, let them be given an office, where to see a hall, but they must follow the standards, international and ratified here of fair hearing and all of that. But if they do so, if LC1 courts are delivering very quick justice on issues of goats and cows and land, let them be empowered to do so. That is the only way. Because, Moses, I traveled the country, all over the country, out of 137 districts, more than 100 don't have one lawyer. One lawyer. And you people here joking, saying you're the arbiters of justice. And yet after law school, you're going to be looking for the top law firms in Kampala. You don't want to go and sit in Katakwi that doesn't have one lawyer. So I think tribunalizing justice, but on the standards, works to bring real justice to normal Ugandans. And then what matters is now the avenue for appeal, where we can now find these great minds who have studied law for 5 years and have 10 years of experience to rule better. But as the ordinary Ugandan experience.
But even as it stands now, the Supreme Court has said that they have no jurisdiction to even hear appeals from the court martial. So now what is the fate of people like Major or something, who has traversed the entire judicial system of the court martial, and now the Supreme Court has told him that we cannot hear your matter. I think let's pick it up from there after the short commercial break, and see you after that.
Digital rights are those human rights and legal rights that allow individuals to access, use, create and publish digital media, or to access and use computers, other electronic devices and telecommunication networks. Digital rights include a right to freedom of expression, information and communication through technology, a right to privacy and data protection, a right to credit for personal works, a right to universal and equal digital access, a right to identity, a right to anonymity, a right to be forgotten, and a right for protection of minors, among others. The state's digital rights are frequently violated through various unfair actions, for example, blockage of websites and social networks, theft of credentials, unauthorized use of people's data for personal gain, privacy intrusion, online censorship, arrests and intimidation of online users, internet blockages, and a proliferation of laws and regulations that undermine the potential of technology to drive social, economic, and political development worldwide. It is hence every citizen's responsibility to respect rights of other digital users and to speak out or report to the responsible parties when one's rights are violated.
We'll be back from that short commercial break. So we'll just continue with the discussion around rights, and you can see we are trying to explore as much as possible. But I think one contentious matter is the rights of women, and because I have two ladies on the show, I'm tempted to talk about the rights of women. Agatha, yes. Women in this country in terms of economic, political empowerment is that yes, we see them in positions of power. You have a Speaker of Parliament, Vice President, Prime Minister, all these powerful women in positions. Then, of course, that is juxtaposed with Article 33 of the Constitution. But are you comfortable with the level of the rights of women?
Yeah, at least there is some bit of comfortability now compared to the ancient days. Yes. So
irrespective of the gender-based violence that still happens, you're satisfied that at least you have a speaker who is a woman?
Yes, that's what I'm saying.
Let me, okay, I can see she's shaking her head. Yeah, let me just hear your opinion.
Well, rights of women is something that, well, it has improved over time. Regarding things to do with domestic violence, we see at least there is a reduction even when it is still happening. But even when we still have women in positions like Speaker, like Vice President, we think that is not enough. At a time when you have women as the biggest population of the country, I think the representation we have is still not enough. Maybe that is on the political side. Then if you go to things like the economic empowerment, notice that for society to thrive, you need women to actually be economically empowered. You need women to reach a certain level of like that kind of economic standard, or that women are able to support families for you to have a functioning community, for you to have a functioning country at the end of it all. So even when people say women have actually achieved what they have achieved, I feel like it is not enough yet. Women up country are still struggling. We have young girls that can actually not access like sanitary towels.
Yeah.
We still have a lot of problems. If you go to Karamoja, if you go to even like regions like Western Uganda, when people say things are good there, like there is still a very big gap. Women are still struggling. We still have women that actually go and dig, and at the end of the season they have to give this money to their husband to go and maybe go and drink alcohol, or maybe go and marry another wife even. So that is how I think it's not really enough yet. Even when we have representation, even when we have people that have come up to empower people, well, we appreciate that there is something that has happened over time and has changed what society was, but still there is a very big gap, that we still have a very big percentage of women or young girls that are still struggling.
So do you believe in affirmative action?
Yes.
You do?
Affirmative action is something that we cannot do away with as for now. I do not say men are not, well, people have come up to say that women empowerment is overshadowing what men are supposed to access at the end of the day. But why I think that is not an issue is that
because now at Makerere University you have more ladies than men.
That is justifiable. The country's population shows you that actually we have more women than men in the country. So I guess that's not like a really big issue. But even when men have come up to say that men are being left out and are not being empowered, notice that society problems about women are actually still very many. Women are most vulnerable in society. Women have gone through a lot of historical challenges in the past, and therefore need that kind of empowerment over time. And I think it is not something that needs to be done just once or twice, but just needs to be consistently done. And not ignoring the boy child anyways.
Yeah.
Like boys also need education, need health care, and all these things anyways.
Well, Sam, let me hear your thoughts on the rights of women.
Well, as they've said, in terms of affirmative action, in terms of the efforts of at a systems level, legal level, to empower women, to make sure in district councils, at all levels of government, in terms of ministries, appointments, and all of that, the government has tried its best. It's a model in terms of that, the framework for supporting women. But also, if you look at comparatives, I went to Kenya and I couldn't believe what I was seeing. You find committees with no woman. Look at their cabinet. Look at their the NRM, for example. Half of the neck is women, slightly more than half. In UDA, the ruling party of Kenya, there's only one director, and it's normal. So I think at the framework level, we're doing well, but there's a huge challenge because this framework, which is quite progressive, is falling on a conservative society, a society where we still find so many abuses against women, physically, economically, and all of these problems. And so that is where we come in as people, putting the government aside. How do we then push for this fight against women? Okay? Why are the increasing cases of rape, including rape where HIV is spread, including assault? These cases are not being moved. And I think one of the issues comes back, we were arguing before the show about lawyers. But in terms of women's issues, I think lawyers have done women a thorough injustice, including women lawyers.
Sure.
Yes. Because when we come to now organic growth of women's space in Uganda, it is not only activism that is going to push us. Okay? A lot of real justice is at a litigational level. When we lawyers gang up in so-called women's organizations and human rights organizations here in Kampala, hosting conferences in Serena and having a good time, taking coffee, you don't help that woman from Kasenyi landing site who has just been raped by a fisherman and has contracted HIV.
True.
And is before a magistrate who is a god, court of no record, can decide her fate, and has a deal revenue target, is issuing out non-cash bails. The cases are being registered as assault. So I think we have let down women in the sense of real justice, because real justice is not activism. I remember when we came to Makerere during the elections, we were trying to say the heartbeat of justice is litigation. And that, why is it that you've just stated the statistics? There are more women lawyers in law school than the gentlemen. But when you go to litigation, it flips, and not slightly. Over 90% of litigants available to try issues of women from Kasenyi and what are men. They have no natural connection to the plights of women. The policeman she's going to report to is a man. The magistrate is a man. Her lawyer is a man.
So where's the safe space?
So where is the safe space? But instead, we lawyers, we sit there in Makerere saying Black Thursday and celebrating FIDA, celebrating FIDA. And instead of what we should be studying in law school, we should have special moods where guys defend women lawyers. So guys defend the victims, and these girls who
prosecute.
Prosecute or defend. You should be really skilled in the art of defending the worst rapists throughout law school, so that when you get out, you can defend the victims.
The victim.
But if you spend your whole law school celebrating FIDA Day and
FIDA at 50,
FIDA at 50, you're going to get out without the skills. And so, at a real, in terms of law and litigation as a cause of human rights, we have failed. I've told you, over 100 districts don't have one lawyer. So what aren't women being raped in those districts? Where are you guys? Where are we? The justice system, litigation, there are no female litigants. And I urge you guys, if you love women, go out there, start a law firm. defend women. Don't join. Don't waste time in Uganda. You can always be a member, but if you ignore litigation, I think we're just digging out our. If there are issues with sanitary pads, raise a case, a class action against the state, and maybe something will change. Maybe it will propel a private members bill to remove any tariff barriers and all these issues on, or maybe even make pads entirely free. So I think the justice of women at a framework level is well, everything is well, but there's a class of us who like discussing women's issues on shows, at Serena, who are gatekeeping the real justice, who don't care about the women down there in Madiokolo, in Kalangala, in Namaingo, who are being raped day in, day out. The only lawyer there is a law student in second year, who is also a guy. And these women must face the hard of going to a police officer. Let me tell you what's going on. You go to a police officer with rape. First of all, you guys know the standard of rape. There has to be tests. But a woman spends days to get through the trauma. Goes, they say the least you can get, the best you can get, write this as assault. That's a male police officer. Then the male lawyer is advising the same. They go before a male magistrate who says, fine, let me give the what? This is assault case, let me give non-cash bail. But you know non-cash bail, what it means? That there's cash flowing in another direction. This is a woman who has to deal with all this kind of men. And we have left them there. So that is my issue, that we elitists, we have really abandoned the real women down there. And we prefer to talk on shows and Serena.
Agatha, you are an emerging lawyer. You've had some has put to you a clarion call that if we are to address the plight of women, the women must themselves be at the forefront of this. Do you think women have somehow, either by an act or omission, played a part in the dire situation that we find women in today, more so in the rural communities? Have you been, part and parcel of the problem?
Personally, no, but me, I feel, compared to what has been initially happening, I feel there is a great change. Why do I say there is a great change? Women have driven themselves out of fear. Because then, a woman would look at herself, how do I even stand in, how do I contest in to be a woman MP of a particular place? But sensitization in the community, that education that has been trending on, amongst people, has driven out fear from people. So people now, the women, we women, we now stand chance, without fear. I can now be this without fear. And when it comes to when some said we should try to defend the worst victims.
No, the worst rapists.
The worst.
So that you learn how to defend the victims when you're out in the field.
But also as a mood, not in the real world.
Yes, in the
real world.
in the real world. There is
what's wrong
nothing
with
wrong.
you two being the best rape lawyers, and in a case between Kidega and a lady, you're like, what's it called, League of Justice, superheroes. You say we switch. Today you represent the villain. After all, it's in your hands. You know the tricks. You guys should own that. That's litigational space.
Know it from both ends.
Yes.
Yeah.
But where do we leave the victim herself?
I mean, she's there. You guys can switch. Say today, I'm defending the victim. Today you defend the rapist. And in the end, 30 years from now, you'll have thorough jurisprudence being read by a law student on a matter you handled on rape. A thorough precedent.
I think it's a gradual process to learn.
Well, if you don't waste time in activism.
It's a gradual process to learn.
Yeah, but just so you don't lose your line of thought.
Yeah, sorry.
Is basically, I think what Sam is telling us is the participation of women in this process. How significant
and where it matters
is it?
most.
Yes. So how best can women be, I don't know, encouraged to own up these processes and be a part and parcel of it, so that they don't leave it to fate and to nature? Is it about having more women having, access to education? Is it about I don't know what needs to be done for us to ensure that you have as many empowered women that are empowered, but also have the ability and the interest to actually put themselves at the forefront of trying to address some of these women issues.
Yeah, I think I would look into, in terms of the education sector, so many people would want to study, but how? I think if government can put in place an increment in scholarships for the women that have that interest in going back to school, like to further their education in specializing in particular fields of their choices, and maybe also in motivating people, motivating more so, should I say the standpoint should be women? Okay, motivating them. Like, let's say there is, we are having a conference somewhere. It should not be, the men should not be the lead, but at least motivate them that a woman can stand and speak and something happens. At least there is a transformation out of a woman's tongue.
Yeah.
So I feel motivation and maybe putting scholarships in place, like for people to further their education. People would want to go back to school, but they don't have they don't have funds to fund them, like to go back to school. But if government can like put in more efforts in looking for scholarships from different countries or even within, I feel that bridge, it would really work out. The bridge can be blocked.
Can be blocked.
Yes.
And bridged, rather. Yes, Melody. Let's move to one very contentious right that has, been with us for some time. Bail. The president has made this position clear more than once, or that on the issue of bail for capital offenders should not be granted by court. All right. So, where do you place your own thoughts that there is a right to bail provided for under Article 26, around there?
23.
23.
Yes.
Yes, but then you have a president who is saying that, but these are capital offenders. Why should you release them back to the public to go and cause more mayhem? So just how delicate again is the right to bail?
Well, I think now one thing we need to first understand is that individuals getting detained or something for whatever crime they have done, the biggest intention is always for them to change, right? Are you able to get rehabilitated in that kind of particular prison they have taken you to, or things like that? And notice that for you to get now bail so that you get back to society is one important thing to like help you with rehabilitation as a person. So when you have done a crime and then you're granted bail, then it means that you're able to like get back to community, get back to family, and things like that. So for the president to come out and say that capital offenders are people that should actually stay detained in those kinds of cells and things like that, then becomes very problematic. That actually what the intention of the entire system looks like is not what we are going to achieve then. For us then, so you notice that for, like I said, for people then to change is for them to be in those cells, teach them how they are supposed to be, and then take them back to community. So then when you say that they should stay in those kinds of cells with the kind of torture that we were talking about earlier, then it becomes very hard for them then that they're actually going to become more of criminals than actually change for the better. So granting bail is something that is really good. And I would not really like love to see someone stay there forever and ever. Like, let people go there, understand the crime they did, so that they can easily change for whatever best is for them and what is good for society.
Yeah, interesting. Our time is fast spent. I'll give us just each 3 minutes. Just make your parting shots and maybe talk about whatever right issue that we have could have missed out. So I'll begin with you, Sam, Agatha, then Melody.
All right. Thank you very much. The state of human rights overall, I think we are a fairly progressive country. I think we have done well on many levels, especially the foundational levels. We have the right systems. In some cases, we exceedingly do well. It's around refugee and other forms of rights. However, there are areas where we should improve, and there are mistakes we should not continue making. I think the judiciary and the justice system in the equation of the balance of powers is the one with the mandate in the social contract on behalf of us to be able to manage and midwife our progress in terms of organic growth of justice. Justice grows organically through litigation, it grows organically through cases, it grows organically through precedents set by these courts. And therefore, my biggest issue is with that sector, of course. I think that the judiciary, in some of the decisions they make, including the Supreme Court decision that court-martial, I mean, courts have no appellate powers on decisions of court-martial. And these are radical affectors. We should not get to a point where people who oppose the winners of the day politically don't find recourse in courts. The minute opposition cannot petition in courts and they lose trust, the next thing is conflict. And these are our days of our youth, of our families, of building wealth. So we should not just watch on, should critique intellectually or otherwise. The office of the Minister of Justice, the Judicial Service Commission, who appoint judges, they need to get more thorough with this work. It's not a joke. Trust me, I've moved to villages. Magistrates are gods. They decide the fate of women who are raped. They decide who gets land. And so the power must be bestowed in the right hands. Otherwise, right now, court is the judiciary is in a crisis. People cannot trust the law. Land issues have a transactional method. Raped women have become revenue targets because the rapists are given non-cash bail, and the issues of statements coming out from the Attorney General. It's terrible.
Yeah.
It's terrible on so many levels that we cannot discuss right now. And I think as young lawyers, we should know that this affects the country. The judiciary is the insurance of a legitimate state. And once it's gone, we have to rebuild it from start. So I think that is one thing we need to stay alive to. Otherwise, let us get into the actual game, be it political, be it legal. Don't delude yourselves with they say you're an engineer. If you watch the 27 Guns movie, they said one engineer is as good as 1,000 activists. So let us go into the actual engineering of human rights, the topic of today, which includes politics. When I say ordinary people can actually deliver justice, I'm speaking from a sociological, political sense. And maybe someone would call me a populist. But I genuinely see how people can solve problems, and we can empower them with our law, our legal standards. The problem is that we have not given them the standards. That's why we are saying they can't, but they can. And then in law, there's a lot of room for strategic activism through litigation. You go pick a woman, defend her. There in Kasenyi, there's a lot of rape. And sometimes they contract HIV. Go to these fish landing sites. Take your time. Take law politically. And then you can have an answer. Otherwise, these talk shows are just, at the end of the day, just shows. The dinners they will call you for, at the end of the day, just dinners. But the woman in Namaingo needs you. And so I think politically, we can play politics through being lawyers who are in politics, which there's a sufficient lack, and then being litigants who actually go down. At the end of the day, think about the ordinary 46 million Ugandans, of whom 90% don't have access to a lawyer. One. Thank you very much.
Wow, interesting thoughts. Agatha.
Yes, please. Like the right to bail goes back still to the presumption of innocence, the right to the presumption of innocence. So I believe just as some has said, like some has said, and the person who is in Namayengo might be suffering injustice the other side, and would also want to, in one way or the other, want to face justice. But how? They lack the funds. So I feel the increase to pro bonos should be put in place. Like, at least, I hear a pro bono service is given once in a year. That is what I hear.
40 hours.
Yeah, 40 hours per year. So I feel if they can increase the number of times of pro bonos at least in a year, and maybe these legal aid clinics be extended to the rural areas to access justice, it would really make sense and also strengthen up the legal system. Then when we talk about bail, obviously bail is not something, it's not automatic that someone should be granted bail. There are criteria like court considers to grant that bail. So because there is no way someone who has committed murder and someone who has committed murder be granted bail, and how sure are we that when that person returns back to the community?
Did you say committed or accused?
Sorry.
Allegedly. At that point.
No, sorry. Accused of murder. I don't find it necessary for such a person to be granted bail. Why? How sure are we that when that person comes back to the community, is the community safe? How safe is the community?
You spoke about presumption of innocence.
Yes,
at that point, are they guilty?
At that point, they are not guilty, but I'm talking about, like, because someone committing murder will not look into, let's say you've been committed to High Court, and you've now known, you've understood you've been committed to High Court, but you still go ahead and want to apply for bail, something that you feel is not, it's not possible for you to apply for. So we also look at the security of the community. If such a person comes back to community, how safe is that person? How safe is the community?
I agree.
How
Murderer
safe?
should not be released.
Yes, a murderer should not be released.
Okay.
An accused.
No.
Okay, that's analysis paralysis of the legal.
An accused person. There's still an accused person. So tomorrow, if I don't know for whatever reason, they fabricate charges and trump up charges on you and say, but what you did this.
Well, at the end of the day, it's the discretion of the judge. But in principle, I don't now like serial rapists, serial murderers accused. But even in accusation, there's discretion. There's room for discretion, and that's why, for example, when Nicholas posted, there's a post. There was guys' phone bending the gate, and Alan Kasinje posted that we have captured the thieves who have been torturing, and they were really code bending, and the gate was bent. And Nicholas Opio posted that.
I need to look at it.
That these are, why are you calling them thieves? They assumed, and the whole public on Twitter came and said, Opio, you must be mad.
Yeah.
If this was your gate, would you say presumption?
Presumption of innocence.
But there's that, I think
point.
Where we are getting to is there has to be discretion for greater good. What works for greater good, and of course all these things need a set where rule of law applies.
Yes, your final thoughts. Were you done?
Yeah.
Yes, we have the final words.
Well, thank you for having us, Moses. My final thought about human rights is human rights we need to focus more on what the local person wants. How can we help the local woman? How can we help this local child? How do we help this child on the street and things like that? We do not have to keep in classes saying we are studying what Children's Act, the Children's Act looks like. We do not have to keep studying what women's rights look like, when we're actually just studying it for the sake and are not going to put in practice what we're actually going to study. So the most important thing is that how are you helping this woman in West Nile? How are you helping this woman, like some were saying, in these fishing sites and things like that? So it's not generally about you celebrating these dinners, going for talk shows and things like that. It's generally about how do you practice, how do you put how do you put in practice what you have studied, and how are you going to help the local person at the end of the day. That is it for me.
Wow, interesting. Thank you, comrades. Comrade Sam, Comrade Agatha,
Thank you.
and Comrade
Melody.
Melody. Yeah. And of course, to the production team, it's always a pleasure that we have this show airing right on time at 2 p.m. And it has been, as you've witnessed, a fantastic conversation. And until next Wednesday, same time, same place. Bye-bye.